Sam Seder, Emma Vigeland on the Majority Report. Always a pleasure to welcome back to the program Mark Joseph Stern. He is a politics writer at Slate.com. What is your official title there?
I am a senior writer for Slate covering courts and the law.
There you go. Senior writer for Slate, courts and the law. So forgive me for that. And really appreciate your joining us. Supreme Court is, and they don't seem like they're in a big hurry to be adjudicating the question as to whether the leading contender for the Republican nomination is allowed to even run for president because of his involvement in what I think anyone reasonable would have to call an insurrection, or, I think even arguably a coup attempt in some respects. But walk us through. This is all centered around the 14th Amendment, Section 3. Colorado has deemed Trump ineligible for the general election. Same too with Maine, is my understanding. What are the implications of this case? Will it affect other states? If the Supreme, but go ahead.
Sure. So, yeah, the Colorado Supreme Court and the Maine Secretary of State have both held that Donald Trump cannot appear on the ballot under Section 3 of the 14th Amendment. And that reasoning applies to both the primary and the general election. Okay. Section 3 has a provision which states that any person who has previously taken the oath of office and then engages in insurrection or rebellion against the United States is disqualified from holding any office, civil or military, in the future unless Congress grants him amnesty by a 2/3 vote. Now, as you said, I think it's very clear that Trump engaged in insurrection. He incited the attack on the Capitol. He fomented the obstruction of counting of electoral votes. The deeper questions here really, I think, involve the process by which Trump could be knocked off the ballot. And you sort of hinted at that just a second ago. I think it's the right question to ask. We have Colorado and Maine rendering these decisions. What about other states like Michigan, for instance? Well, in those states, there's not as clear a path for voters to challenge someone's inclusion on the ballot. And so those courts have not allowed Trump to be knocked off the ballot or even seriously entertained the question. And this may be the biggest issue here. Congress has not laid out any clear procedure by which a insurrectionist can be taken off the ballot anywhere. And so one of Trump's main arguments is that Congress needs to pass some kind of statute explaining how the 14th Amendment should be enforced here. And that even if that's not right, that he wasn't afforded due process in Maine or in Colorado, that he deserved like a full trial, a fuller hearing, more notice and process before he was removed from the ballot. And those are the questions that the Supreme Court's going to confront in exactly 1 month.
We had a caller yesterday who called in and told us that there was part of Section 3 that was actually repealed by Congress in the wake of Reconstruction that presumably was a mechanism in which to determine if someone was an insurrectionist. Like, this was passed specifically in response to the Civil War and to people who were fighting for the South, for the Confederacy. They were engaging in insurrection against the United States of America. And then there was part that was repealed that ostensibly was about, like, what was it? Was it defining who was in that, or that made it that in some ways it seems to me made it more applicable to Donald Trump than less? But go ahead.
So Congress can't repeal a constitutional amendment on its own, right? That's not legally possible. But what Congress did during Reconstruction was pass a very broad amnesty act. Remember before I said that Congress could lift this restriction by a 2/3 vote? Congress enacted by a 2/3 vote this sweeping amnesty for Confederates who had participated in the Civil War. Basically, had a bit of a change of heart. More racists were in Congress. Everybody wanted the North and the South to get along so they could go back to being racist together. And Congress said, we're just going to let these former Confederates do whatever they want, pretty much, including run for and hold public office. So we're going to grant very broad amnesty to all of them. Now, the argument that I think this caller made, which is one that Trump has made as well, is that the Amnesty Act that Congress enacted back then projects forward indefinitely. That Congress didn't just grant amnesty to former Confederates, but actually effectively lifted the ban in Section 3 on insurrectionists holding office by granting future amnesty to everyone who engages in an insurrection moving forward. I think that is a very weak argument. First of all, as I said before, it would basically mean that Congress was repealing a constitutional amendment, was repealing Section 3 by legislation. That's not really legally possible. But also, I think it defies common sense that when Congress was looking backward and trying to give former Confederates more leeway to run for office, that it was also somehow looking ahead to the future, granting this permanent amnesty to insurrectionists who participated in an insurrection that hadn't even happened yet. I think that's a very weak argument. I don't think it's one that the Supreme Court will embrace.
What's the strongest argument that you think Trump has to avoid disqualification in these instances?
Well, I think the strongest argument is a policy argument, not a legal argument, which is that we're in uncharted territory here, and removing the top Republican contender from the ballot would shatter a lot of people's belief in democracy, including, I think, a lot of non-Trumpists who believe that whatever the 14th Amendment says, the American people deserve to have a vote here, and that a handful of judges and state officials shouldn't be able to unilaterally remove him from the ballot. But the Supreme Court says...
Let me just say something. I mean, that is a typical liberal, namby-pamby, living constitution. That's not what the text says.
Exactly
right.
That
That is not what the text says. And I am a newfound originalist and textualist, and I don't care what the outcomes are. That's not my job as the judge to think about what the implications of any type of ruling are. I'm just going by what's in the text by the founding fathers of the framers of our Constitution. And so
balls and strikes, baby.
Balls and strikes.
So, I mean, you got me. I don't know what to say. I think that you've also kind of got the quandary that the Supreme Court is in, because, of course, the originalist conservative majority has claimed that they don't care about policy or politics or even outcomes, right? In the big Second Amendment case 2 years ago, when the court struck down bans on open carry, it said, look, judges shouldn't even look to whether gun restrictions are saving lives. It is not our business whether this has a positive outcome. All that we can look at is what people understood this to mean in 1791. And so I think if you go by that reasoning, there are really very few good arguments to keeping Trump on the ballot. I think there are few good arguments why Trump should be able to remain. I think that the original meaning of Section 3 was very clearly designed to be anti-democratic in a sense, right? The people who ratified Section 3 of the 14th Amendment thought that maybe the future voters of America couldn't be trusted to keep insurrectionists out of office. And so we needed a constitutional bar, just like they thought we needed a constitutional bar on presidents running and holding office for more than 2 terms or running for office before the age of 35. There are other restrictions in the Constitution. This appears to be one of them. I will say, if I'm just putting my legal hat on, I think that the best constitutional argument that Trump has here is that the way this has gone so far in Colorado and Maine, maybe in a few more states, we'll see, it does feel rather freewheeling and improvised. What the voters in Colorado did who challenged Trump's placement on the ballot was use this procedure that's usually done to say, like, a school board candidate isn't sitting in the right district. Like, their house is a mile over the line, and so they can't run for the school board seat. They used that process to force a hearing on whether Trump engaged in insurrection and was thus disqualified from holding office. A lower court state trial judge in Colorado held that hearing, drew her conclusions, and basically that was the basis of the Colorado Supreme Court's decision. Similar thing in Maine. The Maine Secretary of State held a very informal hearing. Evidence was put forth, and she just sort of decreed, yes, this was an insurrection, and Trump incited it. That's not usually what due process entails. Certainly not for criminal matters. This is not a criminal matter. It's more like a civil matter. But even then, I'm concerned that there aren't any clear safeguards here that would, for instance, prevent a red state from trying to weaponize its own judiciary to keep, say, Joe Biden off the ballot by claiming that he aided the enemy by allowing too many migrants to cross the border and persuading a ultra-conservative judge in state Supreme Court to knock him off the ballot. I think that what we would really like to see here is Congress step in and define these terms and define the specific process by which Section 3 is applied. If that happened, I think everybody challenging Trump would be on much firmer ground. In the absence of that, it does feel a little bit iffy to me.
That part also, that's where I think I think that's ultimately where they're going to rule. I mean, that to me strikes me too. Like, to have a magistrate determine what the threshold is for insurrection at that point. But what if the Supreme Court finds that, like, the process in which to determine, even though it's not necessarily, you don't have to get to the bar of a criminal charge here because it's just a classification of something relative, not as to whether they go to jail, but whether they're eligible, if they're insurrection-y enough to not be eligible for the ballot. But what if, like this case that Jack Smith is involved in, the election interference one? I mean, what if it's found that he's not immune from it and he's found guilty? And I don't think that case will actually be resolved in time. But theoretically, would the Supreme Court be basically saying, like, we're going to bring this back down, and we need a better process for how to determine the insurrection? Because they can't also say there is no provision here, like that part of the Constitution is like an appendix. Like, it's just some vestige of a bygone era and it's not doing anything. So we never pay attention to the 14th Amendment, to Section 3, unless Congress does something else, right? I mean, they can't really say that, can they?
Well, I mean, they can say that. They have said that about the Establishment Clause and the separation of church and state, for instance. But I take your point. And I think that the deeper concern here from the justice's perspective would be that they would kick the can down the road if they did that, rather than sort of definitively resolve this, at least for the 2024 election. If they say there wasn't enough process, or this wasn't defined clearly enough, or we aren't entirely sure what this means and we need more hearings or briefings or research or whatever, that just gives progressives more space and time to come back around and say, okay, well, we did everything you asked, and we still think that Trump needs to be removed from the ballot. I think that if the court takes this route, what it'll probably say is that Section 3 is not self-executing. That is a legal term, which means that Congress actually has to pass legislation that specifically enforces the insurrectionist bar through a very specific process. Congress would have to define what insurrection means, again, sort of lay out how you can go to court and challenge someone, how states can have the authority to remove somebody from the ballot. That would be, I think, essentially killing off Section 3, because we all know Congress isn't going to do that. When will there ever be 60 votes in the Senate to enforce Section 3 by creating this kind of structure? But it would be a kind of statesman-like way, I'm using air quotes there, for John Roberts to resolve this case while pretending to adhere to the Constitution, but really addressing the underlying policy concerns.
Okay, let's move to Idaho. They have a complete ban on abortion, essentially. And the Biden administration, in an attempt to at least have some leeway for women to get an abortion, even in those states that are not that have banned it, essentially reminded states that if you have a hospital that operates and receives Medicare money, which is just about every hospital in the country, that there is a provision there that emergency care must be given, if necessary, and that includes abortions, if a doctor deems that a woman is in a state of emergency. Now, in a practical terms, that's difficult because in the same way that these supposed exceptions in abortion laws are so vague that it puts doctors in a position where they're like, this is never a binary cut and dry thing. I'm going to have to go and make an argument that like a 60% emergency, a 50% emergency, a 70% emergency is a real emergency, or 30% or 40%, whatever. And I could lose my license. I could go to jail if I do this. So from a practical standpoint, it's a little bit secondary. But as a legal standpoint, this is the case that the Supreme Court is going to have to look at, right?
Yes, the Supreme Court has taken up this case and will decide exactly what federal law requires. I think you described the facts well. I would just say this statute says that hospitals have to provide stabilizing care to a patient in emergency distress to resolve their medical emergency. Idaho law, like a bunch of other abortion bans, says that you can't terminate a pregnancy until basically the patient is dying. They're either very close to death or very close to permanent impairment of organs or other major bodily functions, which is another way of describing close to death, right? So there's a delta between those two standards. You stabilize a patient before they're that close to death. And what the Biden administration is saying is, look, federal law is supreme over state law. So Idaho law might say you can't terminate a failing pregnancy until the patient is dying. But federal law says that you have to provide stabilizing care when they're in distress, but not yet at the point of death. So we think that federal law reigns supreme. The Constitution says so as well. And we think that it preempts any kind of state law, whether it's Idaho or Texas or some other red state, that forces women much closer to the brink of demise. A federal judge in Idaho agreed with the Biden administration. Different federal judges in Texas disagreed with the Biden administration. The Supreme Court has now stepped in and will resolve the case. A rather ominous sign, though, is that while doing that, the Supreme Court actually stayed the Idaho decision that had sided with the Biden administration. So for the past year plus, if you had a failing pregnancy in Idaho, you had a right to stabilizing care, including an abortion when necessary, because of this ruling. The Supreme Court just lifted that ruling, which means that Idaho law kicks back in, and you have to be much closer to the point of serious organ impairment or death before you can obtain emergency treatment. I am not optimistic about how this case will turn out at the Supreme Court. The signs are pretty bleak, but I guess hope springs eternal.
Can we just talk about how much BS is involved in the idea that you can stabilize someone on the brink of death? Like, I mean, what does that mean? Like, at what point? Like, I mean, if we just look at this, like, this is the whole fallacy of this whole thing, too, right? Like, when is someone about to fall off a cliff? Are they like, is it 1 foot over? Is it 90% of their body weight that is over that cliff? I mean, there's no, this is all subjective.
And if there's also this legal threat to the person who's supposed to pull you back from the cliff, that if they are not sufficiently close to falling off the cliff, that you could face literal prosecution or loss of your license if you don't let that percentage get a little high to meet that threshold.
Right. So this is the problem and vividly illustrated in Texas, which has a 99-year prison sentence for any doctor who provides an abortion that does not fall under the state's extremely narrow medical exception. Doctors are looking at patients coming in. They have infections. They are bleeding out. They have amniotic fluid leaking. Their pregnancies are clearly doomed. And the doctors say, look, I don't want to go to prison for 99 years, so I am legally obligated to wait until you develop sepsis or you are hemorrhaging before I can legally terminate that pregnancy. The state has come back and said, that's not true. These doctors are misreading the law. We would never pass a law like that. But then when Kate Cox actually went to court and said, I have a failing pregnancy, I am bleeding, I have amniotic fluid dripping down my legs, I need an abortion, the Texas Attorney General swiftly went to court to block her abortion and in fact issued a threat to every medical professional in the state of Texas and said, if you provide an abortion to Kate Cox, we will prosecute you to the fullest extent of the law.
I wish you had better news for us, Mark, but it sort of feels like consistent with every conversation we've had for several years now.
Can I say one positive thing? One sort of positive
sure.
thing? I think that the Supreme Court will deny immunity to Trump in his criminal trial. This is something that I know you mentioned earlier. It's obviously a big topic. The Supreme Court doesn't seem to be in a huge rush, but I really do think there will be a lopsided majority vote to deny Trump immunity. And I think there's a real chance that that decision could come down with enough time for Trump to be held to a criminal trial in the District of Columbia. Not sure on that last part. The justices can certainly drag their feet when they want to, but this argument for immunity that Trump is making, I think the fact that he's making it so much and so strongly can give the impression that it has any kind of constitutional basis, but it doesn't. It's completely made up out of whole cloth. And even a conservative judge on the DC Circuit, Judge Karen Henderson, recognized that pretty clearly in oral arguments this morning. So, even though a lot of the news right now is bleak, these arguments that Trump's raising to try to scrap these trials altogether, I really don't think it'll hold. And I think even his own appointees on the Supreme Court will recognize that it's bogus.
Isn't it weird too, though, that Trump's lawyer said Kavanaugh is gonna save us? Does it? I mean, is it me, or is that like the worst thing you could possibly say going into a court case? Putting a specific justice on notice that, like, we expect because you got appointed by Trump that you're going to do what we want. Isn't that the way of basically making that judge go like, oh, geez, there's no way I can rule that way?
Yeah, I don't think that Trump's legal team are the best tacticians. I think that's become very clear in this latest round of litigation. They seem to think that that puts the pressure on Kavanaugh as if to say, remember who saved you, remember who you owe fidelity to. And I guess I would say I do think that Kavanaugh feels some sense of gratitude toward Trump for standing by him during Christine Blasey Ford's allegations of sexual misconduct. But Kavanaugh has this seat for life. He's still going to be there for 30 years. Sorry if that, makes you feel very bad inside. But he doesn't have to do anything for anyone. And so I am skeptical that that kind of statement or any other pressure is going to have any impact on how he decides this case.
That's what I would have thought. Unless, of course, it was Trump who paid off those bills that he had. But I don't think that's him.
Now he has access to the Leonard Leo piggy bank. He can get as much money to pay off his debts as he needs.
Exactly. Mark Joseph Stern, always a pleasure. Really appreciate your time.
Thanks so much, Sam. Thanks, Emma.
Yep. Thanks, Mark.